The First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. The New York Times v. Sullivan case of 1964 was a case between Sullivan, a Montgomery, Alabama commissioner, and the New York Times. The New York Times published an article that had a number of inaccuracies, false statements, or exaggerated statements about Mr. Sullivan, a public official. Mr. Sullivan felt it harmed his reputation as it was his job to supervise the police department, making him look as if he was not doing his job or was incapable of doing his job. The key element for Sullivan to prove defamation is that he was incompetent in his job, trade, or profession. Since Sullivan was a public official, he also needed to prove that the New York Times knew the statement was false, or that the New York Times acted with reckless disregard as to the truth or falsity of the statement. The Supreme Court overturned the Alabama Supreme Court's decision. They did so because Sullivan could not prove that the New York Times acted maliciously, nor did they know the advertisement contained inaccuracies. Justice Brennan delivered the opinion of the court in this case. The justices voted 9-0, ruling in favor of the New York Times. Gertz v. Welch, 1974. Elmer Gertz was a lawyer who was working on a case against the Chicago police officer Nuccio. Welch was the managing editor of the American Opinion magazine. The article stated that petitioner had been an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated for the violent seizure of our government. It labeled Gertz as a Leninist and a communist fronter. It also stated that Gertz had been an officer of the National Lawyers Guild, described as a communist organization that probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. The managing editor of American Opinion made no effort to verify or substantiate the charges against petitioner. As a lawyer, it could paint him as a communist sympathizer, one who works against that of the United States' laws. This means it could hurt his social reputation and his legal practice as a private citizen. I would have verified the information being correct was accurate, or more properly framed the statements, to avoid false claims on Gertz's character. A false statement, communicated by speech, conduct, or in writing to a person other than the person defamed, and the communication is unprivileged and tends to harm one's reputation so as to lower him or her in the estimation of the community, or to deter third parties from associating or dealing with him or her. The idea of being able to publish any statement about someone else, a business, or anything to me is a privilege. No one should ever abuse this power. I do not take it lightly when it comes to this, and if I am going to speak upon something, I will make sure to check my sources and cite my sources to help avoid issues like this as best as I can.